Next case on the docket today is BUDD versus BEALL'S.
Good morning, Your Honor. Please the court. My name is Kevin Dixon. I'm from Inverness. I represent the appellant Robin Budd in this case. This case is here on a dismissal of prejudice on a motion to dismiss the amended complaint. So your review would be de novo today. And one of the main issues that was argued to the trial court is the application of the impact doctrine. And that's why the court dismissed count 1 of the amended complaint. Factually, briefly, Mrs. Budd was a business invitee at BEALL'S department store. At some time earlier in the morning, employees of BEALL'S noticed an individual who was acting suspiciously, had a camera in his hand, and at that time they thought he was some type of pervert trying to take pictures underneath women's clothes. With that knowledge, they allowed him to stay in the store, and for at least 3 hours watched him and then videotaped him for 20 minutes when he actually stopped and attacked Mrs. Budd.
What do you mean by attacked?
He was ultimately convicted of a crime, voyeurs.
Well, what exactly was it that he did?
He photographed up her dress. And what we alleged in the amended complaint was that was a clear violation of Ms. Budd's privacy. And I think we would all agree that the stranger...
By the perpetrator, not by BEALL'S, correct?
That's correct, Your Honor.
And do I understand? It seemed to me one of your arguments was the impact rule applies in negligence cases, and if the underlying tort is an intentional tort, the impact rule doesn't apply. Is that the argument?
That is not my argument at all.
Okay, you need to clarify that for me.
The way I look at this is, I think we all agree, had Ms. Budd been raped or shot, there would be no question we wouldn't be here. All right?
And conversely, if somebody had held her up with a gun but not shot her, she wouldn't have a claim, correct?
That is absolutely correct as well.
Okay.
The reason is those cases are distinguishable, and I've cited numerous Supreme Court cases, including the Southern Baptist case, as early as 2005, where the Supreme Court says that the impact rule does not apply to certain intentional torts. And we can all agree that a rape or robbery is an intentional tort. But the Supreme Court said that this rule does not apply to invasion of privacy claims. So the way I look at it, and what I argued below, was you have 3 intentional torts. All right? They're no different. And as admitted by the appellee in his brief, if BEALL'S is negligent in their security, and you have these 3 intentional torts, then they're responsible.
Do you make any allegation that BEALL'S engaged in any intentional tort, or is your claim against BEALL'S?
It's grounded in negligence, correct.
Okay.
But the way you get past the impact rules, it doesn't even apply to the underlying intentional tort.
Who cares if it applies to the underlying tort? You're not suing on the underlying tort. You're suing on the negligence.
That is correct. But what they've said is, because there was no impact to Ms. Budd, had there been an impact, all right, we wouldn't be here. And what I'm arguing to you is, because of the nature of the underlying tort, which is an invasion of privacy, there is no impact rule implication. And the sole argument below was because Ms. Budd was not impacted by the criminal.
Why is that different than being held up, an intentional?
The reason that is different, all right, the whole reason for the impact rule is to stop the floodgates and spurious claims. The reason that is different is because the Supreme Court has held that in intentional torts of the type of an invasion of privacy, emotional damages are presumed. All right, so it gets it out of the specious or spurious type of claim. And so if there is absolutely no impact rule involved to the underlying tort, I don't think BEALL'S can hide behind it in this particular case.
Do you have any case that you've located, counsel, that is analogous to this?
Absolutely not. I wish I had.
I didn't find any either, if that's of any comfort to you.
Yeah. And I think the big distinguishing factor on what the appellee is arguing is each and one of those cases is a robbery, and that's one of the cases that the Supreme Court has said impact rule applies to. But when you look at what the Supreme Court has said on the impact rule, it absolutely does not apply to an invasion of privacy. So if you equate the underlying tort from the criminal to just as
But your lawsuit is based on negligence.
That is
They were
correct.
negligent.
But every
Breach of duty, breach of the standard of care, causation, which caused the damages. It seems to me, it's always been my understanding that the impact rule went to the last element, damages. The impact rule didn't have anything to do with duty, causation. I mean, you can establish all that, and you can establish negligence. What you can establish are your damages. And the reason for that is the courts have held that the damages are too speculative. There's no way that the opposing side can in any way establish a defense because there really is none. These emotional damages are something that the injured party will testify to, which basically leaves the door wide open, as you said before, to spurious claims. So it's a damage issue. And when you filed your negligence claim, the courts have said that in a situation like this where there's no impact, and all you've got are emotional damages, you have no damages. You have no claim for damages.
I agree that it is a damage issue.
Right.
So then when you look at the underlying tort, right, it's not an assault with a robbery, it's an invasion of privacy. And the Supreme Court has repeatedly said impact rule doesn't apply. So she therefore would be entitled to her damages for the emotional distress she suffered.
But invasion of privacy is not a negligent tort.
It is an intentional tort, but so is rape, so is robbery, and so are the stores held liable for that if they were negligent in their security. All right, that's what I'm saying. I equate all three because the particular tort that was visited on my client, the emotional damage, it's predominantly emotional damages, and the Supreme Court said no impact rule. And I think that's why the trial court's order.
You brought a negligence claim. Why couldn't you have brought a claim for breach of privacy against both the individual that did this and BEALL'S? Because apparently BEALL'S had known that this person was in the store for some period of time and let the person stay for a period of, 3 hours?
3.5
Why
hours.
couldn't you have brought a breach of privacy action against BEALL'S?
You mean an invasion of privacy?
Invasion of privacy.
I don't know. I thought really it never.
Had you done that, maybe you'd been in a different position, but you brought a negligence action, didn't you?
Yes.
And then you also brought an infliction of emotional distress action.
Correct.
All right.
And, based on the Supreme Court's holding that the underlying tort, no impact, I think the trial court's ruling on that matter should be reversed.
Let me ask you this, even if you don't have any cases that are factually similar, do you have any cases that adopt what I understand your legal argument to be, which is that if the impact rule doesn't apply to the underlying tort, then it doesn't apply in the negligence claim related thereto?
All right, if I understand what you're asking me, if the underlying tort is outside of the impact rule,
Right. That then flows through to your negligence count arising out of it. Do you have any cases that adopt that legal principle?
any of your intentional infliction of emotional distress, that's an underlying tort. Impact rule doesn't apply. I mean, that's why we brought
All right,
this
so
up.
are there any cases which say if you sue somebody for negligence because they allowed somebody else to intentionally inflict emotional distress, that you don't have to show impact as to the negligence claim?
I think you're asking me, do I have cases that are on point with these facts, and I don't.
No, I'm not. I'm asking you whether you have any cases that adopt legal principle, even if factually they're somehow different. Because your legal principle, as I understand it, is although the impact rule normally applies to a negligence count, if there is an underlying if there's an underlying tort to which the impact rule doesn't apply, somehow that exclusion flows over to the negligence count and you no longer have the impact rule.
I don't know of any cases that say that, but the only thing I would argue is to look at the ever-expanding exceptions that the courts have been carving out of this. In fact, I believe there's another one up on with the Supreme Court now.
What is your underlying tort that you're saying excludes the impact rule? Is it the privacy?
Invasion of privacy, correct.
And you don't know of any reason why you couldn't have brought that action against BEALL'S as well?
Only because, no, I don't. I really don't. I don't know why we didn't do that. We just assumed it was a negligent security case. But again, that's why we amended and tried to couch it under the terms of the intentional or reckless infliction of emotional distress. And if the court would like, I could move on to that.
What's your understanding of the philosophical basis for the exclusions that the Supreme Court have recognized to the impact rule?
Because these are the type of injuries that result in predominantly emotional damages. The exceptions, and they're really not exceptions. If you look at it, they're just, the rule doesn't apply. But the most recent ones they talked about is the disclosure by psychotherapists of private information. I think the one up on appeal now is a clergy, where he disclosed private information, and they're saying you were negligent in disclosing this information, there is no impact, but damages are predominantly emotional. So there's no rational reason of applying the impact rule to these types of cases. That's the same rationale that they gave to the invasion of privacy claims.
Yeah, but negligence, negligence in failing to provide security, in most of those cases, you're going to have some sort of an injury. You're going to have an attack. You're going to have a person knocked down. You're going to have something like that. This is one of those, it seems to me, one of those unusual cases where you're filing for negligence based on the fact that somebody took a picture of a customer in the store with no physical impact. So in the case, I think in the cases where the Supreme Court has, maybe you may not want to call them exceptions, but has found that the impact rule doesn't apply, the gist of the cause of action itself has to do with the type of damage where, you don't have to speculate. It's presumed those damages are going to flow, but in a negligence case, it's generally the negligence counts have to do with some sort of an injury being inflicted, physical injury.
I agree this is a unique set of facts, and that's why I couldn't.
Why can't you go back and just file your invasion of privacy claim?
I don't think
You don't think you should have to do that, huh?
Probably a day late on that one. But if the court will allow, I can turn to the reckless infliction of emotional distress.
Is that you make reference to reckless infliction, is that the same as intentional infliction?
Exactly the same.
Okay.
It's called, different cases call it different things. The lower court didn't give any reason for dismissing count 2, either verbal or written. The cases in the impact rule all hold that if it's an intentional tort, which reckless infliction of emotional distress is, the impact rule does not apply at all. So it couldn't have been that.
So then you have to look at whether it's, in essence, whether it's outrageous enough.
That would have been the only other reason for the judge to dismiss.
Which is as I understand the law, is a legal conclusion, not a factual conclusion.
It is, and this court in the Williams of City versus City of Mineola set out the standard. And in that particular case, the police gratuitously showed some photographs and a videotape amongst themselves of the plaintiff's deceased son. And what they said in that case is, in deciding that the conduct was outrageous enough to support the court, this court held whether the conduct is outrageous enough may be decided as a question of law by the trial court when the facts of a case under no conceivable interpretation support the tort. But where facts are disputed or where differing inferences can reasonably...
How do you say that what BEALL'S did was just so outrageous that,
It comes more to light when you read the answer brief of the appellee, all right? Because what BEALL'S does, apparently, and the inference from these facts is they don't want to come in too quick or risk being sued for false imprisonment. So what they're going to do is allow this guy in the store to mill around, even though they know knowledge of his malintent, and wait till he actually commits the crime.
Well, did they actually say, we know this guy is up to no good, or did they say, we suspect, but we're not sure yet, so we need to see what happens?
The allegations of the complaint are they knew he was in the store, they knew he had a camera, they knew he was acting suspiciously, and they thought he was a pervert trying to take pictures of women's bodies. Those are the allegations of the complaint. We get stuck with that on this particular review. And so my argument is, a natural inference from that is, in complete disregard to Mrs. Budd's welfare or her well-being, they allowed the assailant to invade her privacy because they wanted to see the man do the crime so they could have him arrested without fear of any further repercussion. And it's my opinion that's clearly outrageous. And it's outrageous enough to survive a motion to dismiss. And if anything,
There's no debate about the facts. is there?
the only debate I know about the facts was raised in their answer brief, where they say the actual recording that's attached is a little over 19 minutes. The allegations of the complaint that we have to accept as true are he was in the store for 3.5 hours. All right, so the only difference in the facts that I'm hearing is this 19 versus 3.5 hours.
The actions of the perpetrator are pretty much conceded by both sides.
Yes. And so it's our position.
Was there any additional information that the trial court needed in order to come to his legal conclusion that this was not outrageous? What other information could he have had which would have changed his mind?
Maybe a better argument. I mean, the information was there. I do cite in my case under our argument, both arguments actually, the BUDD case, which is the second DCA 1995, which sets out the store owner's duty or an obligation to protect a customer from a non-ongoing attack. And so it would be our position, knowing the guy's in there for 3.5 hours and doing nothing, especially the last 20 minutes, because viewing the videotape, you have to look back and go, well, why didn't somebody do something? And they just never did. And again, the actual video portion of it in the store is roughly 20 minutes. And so we think that we alleged enough facts to show an outrageous conduct, which would at least allow us to get to the jury on the issue, but definitely survive a motion to dismiss.
You're down to 4 minutes if you want to say that.
Thank you. I'll save that for Bob.
May it please the Court. Good morning, Your Honors. My name is Mark Tinker. I'm with Fowler White Boggs Banker in St. Petersburg. I represent the Appley BEALL'S department stores. This case, I believe, is relatively straightforward. As counsel discussed, there's 2 counts involved. The first is negligent security, which brings into play the impact rule. And as we discussed in our brief, I believe that the appellant's argument here confuses Bell's actions with those of the alleged pervert, or the perpetrator in this case.
What about the second count, about the emotional distress count? What about that? Because his argument was that if we look at the 4 corners of the complaint, he let this guy linger in the store for 3.5 hours, knowing he says he alleges that he knew that this fellow was up to no good and was going to do bad things, and yet you let him stay in the store for 3.5 hours, waiting for him to commit a crime. So then, against one of your customers, so then you could be assured that whatever you did was going to be appropriate.
Well, as counsel conceded, that is the key issue there is the question of law as to whether that conduct is sufficiently outrageous to be considered intolerable in society. And essentially, it's the same allegations as the negligent security count that the complaint in count 2 even concedes in paragraph 20 that Bell's was negligent in performing its security of this fellow, and that he then went on to take the photographs. And the key there is that this standard is something that the Supreme Court in Eastern Airlines versus King has said is supposed to be beyond malice, beyond what would be necessary for punitive conduct. It has to be reprehensible, objectionable, and offensive. And what you really have to look at there, and I thought this was kind of an interesting argument that the Supreme Court adopted in that King case, that was a case where there's an airline that had some really bad maintenance done on it, had almost crashed. One of the passengers said, "This is outrageous conduct. I don't believe you performed that horrible maintenance. You distressed me here." And the Supreme Court said, well, that would be kind of incongruous for... Your argument is,
if I understand it, what you did was bad. It just wasn't bad enough.
If accepting those allegations as true, yes, I believe this could be evidence of negligent security, but it's not intentional infliction of emotional distress.
Tell me how it's less outrageous than a couple of the cases from this court which allowed such a count to stand, those being McAlpin and Williams. One was the autopsy photo case, and the other was apparently a physician who verbally assaulted a patient about a debt that was owed to a friend, and in both those cases, this court said there was enough.
The first one, the Williams versus City of Mineola, the court, as I read that opinion, went to great lengths to discuss that this was a particular situation where we're talking about dead bodies. And one of the quotes, this is on page 683 of that opinion, the court discusses the special deference paid by courts to family feelings where rights involving dead bodies are concerned. And it said this is central to our decision, and then looked at outrageousness in society and said that a level of carelessness or callousness which might not be considered tortious in other situations can show outrageousness and recklessness when a dead body or a picture of a dead body is involved. So the court really, in this case, said this is something that is key to our society in general, that most people in general hold feelings towards their dead relatives, and it was actually specifically limited to family members, siblings, those sorts of things. People hold those feelings dear. It would be considered outrageous conduct for people to interfere with that particular situation. So I believe that's clearly distinguishable from a case where you have negligent security with somebody shopping in a store. The other case, what you mentioned is the physician, I don't remember the name of it. McAlphin. This is a case where I believe is distinguishable because, again, this isn't a negligent or something that's considered to be just kind of reckless conduct. This was intentional conduct that happened here. There's a doctor-patient relationship, which first of all it brings into play fiduciary duties and things not present when just a store versus customer case. And you have an individual who comes in for treatment. She already has a fear that she has cancer. She's already stressed. She's coming in for x-rays and diagnostic tests. And the doctor verbally abuses her based upon his belief that she wouldn't pay a bill for a friend of his, said, you're not going to pay my bill either, and I refuse to do your diagnostic treatment, and continue to let her be subjected to that fear of cancer. So again, a different situation. We've got something that generally in society, people are going to look at this and say, I have a fear of cancer, I'm going in for diagnostic testing, I expect my doctor is going to take care of me. This is a special relationship that's involved. That's not present in this case. I did look around. I did not find anything in Florida that applied intentional infliction of emotional distress to a store owner or a negligent security situation. Did find 2 out-of-state cases. The one that I gave a description of in the brief that I think is most relevant was a case out of California, involved police officers who have been watching this laundromat where some people had been getting stabbed. They went to stake out the laundromat, saw a perpetrator come in and stab someone and tried to chase him, didn't catch him. So they set up a plan for the next evening. They had the stakeout in place, saw the perpetrator enter the laundromat, and were too slow in reacting, and he ended up assaulting another victim before they were able to arrest him. And the court looked at that and said, this may not have been the officer's finest hour. That may be a plan that was doomed from the start. They, didn't have a great plan in place. But when you break it down and look at the facts, the essence of what was involved there is that they acted too slowly. They were trying to intervene. They had as their plan to help out. They were just too slow. That's negligence. That's not an intentional or reckless infliction of emotional distress. I believe that applies directly to this case. The BEALL'S employees had surveillance on this person. The videotape is attached to the complaint and incorporated. And although that was one of the factual disputes that were mentioned, although the complaint says in the text of it that BEALL'S did nothing to intervene, the attachment to the complaint, that videotape, shows otherwise. It shows the gentleman being arrested, led from the premises in handcuffs, and put in the sheriff's car. So BEALL'S did intervene. The essence of it is that they acted too slowly. That's at most negligent security. That's not emotional distress. If there are no other questions, I'll yield the rest of my time and ask that you affirm.
Thank you, Counsel.
Thank you.
Just briefly, the out-of-state cases cited by the appellee, I would submit to the court that the definition of outrageous in California is substantially different from here in Florida. But notwithstanding that, if the facts as alleged are proved to be true, the jury could find that it was a policy of Bell's to allow the attacks to happen before taking any action, which is really what the video shows anyway. They don't come in and do anything until after the wrongful act occurred. And that could clearly warrant punitive damages. So it's our position that it's clearly outrageous conduct on behalf of Bell's. On the issue of the impact rule, one of the cases cited by appellee support is Sturgis.
Is that the standard, the punitive damage standard, or I think the opposing counsel may have indicated it has to even go beyond that and be even worse than that?
I don't know. I think it just actually the standard is it must make you scream or exclaim outrageous is what most of the cases say as the standard on that. Back on the impact rule, one of the cases cited by the appellee, which is at Sturgis, the Biscayne Recreational Development Company. In that particular case, they upheld the impact rule. But what happened was a negligent security claim where some intruders entered onto a boat and were robbing the boat, which was a primary residence. The gentleman woke up, had a heart attack, and died. And one of the quotes in the opinion, which I agree with, is, despite our strong view that the impact rule should be abolished, we are nonetheless bound by this state's inexplicable affinity to the impact rule. And I think that's starting to become the general feel among the appellate courts. More importantly, and it jogged my memory after you questioned me on it, there's a dissent in that opinion by Judge Hubbard. And in Roman numeral paragraph 2 of Judge Hubbard's dissent, he explains in great detail the issue we discussed of, well, why would Bell's be responsible for the criminal acts of another, even though they did not cause any impact? And bottom line, he says, but for Bell's negligent security, none of these injuries would have happened. And, of course, he's arguing for an abolishment of the impact rule. But I think he does a good job explaining what I may not have been able to articulate very well. Thank you.
Thank you. Court will be in recess.